Hello everyone and welcome to this webinar hosted by the Garden Court Chambers Housing Team. Our topic this evening is post-Brexit rules on eligibility for homelessness assistance and allocations of social housing under the Housing Act 1996. Before I introduce our speakers, there's a couple of housekeeping matters. So firstly, you've all been placed on mute. Please post any questions that you may have for our speakers into the Q&A window. That's a separate window to the chat function. The chat function itself is enabled for any other comments, queries, or feedback that you may have, so don't put any questions in that box. Secondly, all the resources, so the slides prepared by our speakers today, will be circulated to registered delegates after the webinar. Thirdly, this webinar is being recorded, and that means that the audio and video of the panelists and anyone who speaks, if they are unmuted, will be recorded. This webinar will be shared on our marketing channels, including our website and social media. Lastly, please refer to the instructions in the chat window if you're experiencing any technical difficulties. So this webinar will address changes to the landscape of eligibility under the Housing Act 1996, which result from a range of post-Brexit legislation. Eligibility of EEA nationals and their family members has always been a complex area, and we now know that it has become somewhat more complex. We all need to get a grip with these changes and understand how they affect our clients. Fortunately, we have two brilliant and expert speakers this evening, both members of Chambers, and they're going to guide us through these changes. We have Connor Johnston and Adrian Berry. They are going to, between them, go through all the relevant legislation and outline the position as it is now and as it is going to be as we go forward beyond the end of the grace period, which ends, as you may know, on the 30th of June 2021. We also have with us in the webinar on the panel Desmond Rutledge, who is our resident expert on social security law, and he is going to be available at the end of the webinar for any specific questions which may relate to the overlap between those two areas. First up, we have Connor. So I'm just going to hand over to you now.
Thank you, Angharad. I think, as Angharad has said in her introduction, eligibility has always been a hugely complex area, or certainly I've found it to be so, like perhaps the most difficult area of homelessness and allocation. So I wanted to start with what I hope is some familiar background in order to give you a bit of an idea of exactly what it is that Adrian and I are going to be covering this evening. So I just wanted to start with section 185 of the 1996 Act. Now, section 185 has been amended, but the passages that I've quoted on this slide remain unamended. And as you can see, what section 185 has always done and what it continues to do is effectively to divide the world into two. It divides it into those who are subject to immigration control and those who are not subject to immigration control. Now, those who are subject to immigration control won't be eligible for homelessness assistance unless they're brought into eligibility by regulations, and those who are not subject to immigration control will be eligible unless they're excluded. Now, those regulations which we're familiar with are, in the context of homelessness, regulations 5 and 6 of the 2006 regulations. And the counterpart for allocations is regulations 3 and 4. Now, throughout my slides, I'm going to focus on the homelessness regulations 5 and 6, but everything I say also applies equally to the allocation counterparts. So that's the division of the homelessness world that we've always been familiar with, and that's still the division post-Brexit. That sort of broad framework still applies. So the way that Adrian and I have divided up the materials today reflects that. So the first question when you have an eligibility issue is always to work out whether or not your client is somebody who is subject to immigration control. And then once you've done that, you know whether they're going to fall into Reg 5 or Reg 6, and you move on to the second issue, which is to apply the rules in those regulations to work out whether they're eligible. So what I'm going to be dealing with is that first stage: who is and is not subject to immigration control post 31st of December last year. And I'm then going to move on to the first bit of the second stage and look at regulation 5. Adrian's going to be looking at Regulation 6, and he's also going to be looking at some related issues such as the rules on restricted persons, as well as some miscellany like the amendments to Schedule 3 of the 2002 Act insofar as they relate to homelessness assistance. There is going to be quite a bit of repetition, I think, between our two presentations, and I make no apology for that. I mean, not only is the repetition built in because you are addressing a lot of the similar questions throughout the process, but also this is really complicated, and I hope that in having a degree of repetition, you'll come away from this a bit more understanding of the rules that we have to apply. So that's the structure that we're taking today. Before I move on to the new rules, I just want to say a little bit more by way of background and context about the old rules to give a bit of a sense of what it is that has changed. So you will recall with EEA nationals, and it is primarily EEA nationals we're concerned with today, although not solely, because what we're looking at is the post-Brexit changes. But prior to 31st of December 2020, we have our definition of who is and is not subject to immigration control, which is contained in Section 13 of the 1996 Act. You're subject to immigration control if you require leave to enter or remain in the UK, whether or not you've given it, whether or not such leave has been given. And then reading that with Section 7 of the 1988 Act, a person shall not, under the Principal Act, require leave to enter or remain in any case in which he's entitled to do so by virtue of an enforceable EU right or of any provision made under Section 2 of the European Communities Act. So prior to 31st of December, what that meant in practical terms was if you were an EEA national with a right to reside under the 2016 regulations, then you were not subject to immigration control. That's where things stood prior to 11 o'clock on the 31st of last year. The position now is a little more complicated. So Section 7 of the 1988 Act has been repealed, as have the 2016 regulations, but they haven't been repealed completely and for all purposes. They have been repealed subject to an extremely tortuous set of transitional and saving provisions, which mean that they continue to apply to certain groups of EEA national for certain purposes and in different ways. So that's really what I'm going to be exploring in the first part of my presentation, is what those new rules are, so we can understand who it is that is now subject to immigration control. There is one additional change to the rules on who are subject to immigration control, which doesn't fall neatly within that rubric, which is that there has been a new Section 3ZA inserted into the Immigration Act, which means that an Irish citizen does not require leave to enter or remain in the UK. So they are not subject to immigration control. I'm just going to flag that now because it is a simple and self-contained rule. And then I'm going to return to the position that applies now to other EEA nationals. So, as I've said, the first question I want to deal with is which EEA nationals are subject to immigration control. And people enumerate the different groups differently, but the way I look at it, there are 4 cohorts who are not subject to immigration control. The first is a member of the post-transition period group. So I'll explain in course what I mean by that, but in broad terms, that covers those with pre-settled status under Appendix EU. Second cohort is a relevant person during the grace period who is exercising a right of residence under the 2016 regs. So again, I'll explore that in a bit more detail, but it is targeted at people who have a right to apply under the EU settlement scheme, have a right to apply under Appendix EU, who haven't done so yet in the grace period, which is this window for making applications, which runs from the 31st of December until the 30th of June. The third category is an extension of that category, and it applies after the 30th of June to those who've made those applications, but who haven't yet had their applications determined. And then the fourth category is a distinct and self-contained category, which is those who are exercising frontier workers' rights. And frontier workers are those who are working in the UK, but not primarily resident here. So I'll just break those down in a little more detail. So our first category, the post-transition period group, the rules for this group are actually blessedly simple. A member of the post-transition period group is not treated as subject to immigration control for eligibility purposes, notwithstanding the repeal of Section 7 of the 1988 Act. So what that means is a member of the post-transition period group is for these very specific purposes, not treated as being subject to immigration control, for eligibility purposes only. In real terms, in immigration terms, they are subject to immigration control. They do need leave to enter or remain, but we pretend for homelessness eligibility purposes that they are not. And a person is in the post-transition period group if he or she has limited leave to enter or remain in the UK granted by virtue of Appendix EU or any other immigration rule identified within the immigration rules in connection with our departure from the EU. So that is a long-winded way of describing somebody who has pre-settled status under Appendix EU. You'll note from that second bullet point, but it goes slightly wider than that. It's not just Appendix EU, it's other immigration rules identified as having an effect in connection with our departure from the UK. But for the most part, it is going to be under Appendix EU, and I'm going to use that as a shorthand tonight when I'm talking about this cohort. So if you've got pre-settled status under Appendix EU, you are in the post-transition period group. You are not subject to immigration control for eligibility purposes. So that's our first cohort, and I think that's probably the most straightforward of them, because you should readily be able to identify whether your client has pre-settled status, because they will have a bit of paper telling you that they do. Our next category, I think, is potentially the most difficult one, and this is relevant persons during the grace period. So this category, Section 7 of the 1980 Act and the 2016 regulations continue to apply, subject to modifications, to a relevant person during the grace period. So we're not simply, what that means is that if that person is exercising a right of residence under the 2016 regulations, they are not subject to immigration control. So we're not just pretending that they're not subject to immigration control for housing purposes, they're actually not subject to immigration control. I'll just flag one point which arises from that second bullet point, which I'll return to shortly, which is that the fact that we have to inquire into whether such a person has a right of residence under the 2016 regulations means looking at what they are doing now. So somebody falling within this cohort, to work out whether or not they are subject to immigration control, we have to look at whether they're exercising a right of residence under the 2016 regs now, i.e. are they a worker now, are they a job seeker now, etc. So I'm just flagging that out, that sort of temporal point, that as part of this analysis, we have to look at what the person is doing right now. But taking a step back, what are these definitions? Relevant person and grace period. Well, the grace period, as I've already said, is this window for making applications under the EU settlement scheme that runs from 11 p.m. 31st of December until the 30th of June. So that bit's fairly straightforward. That's our grace period. But who is a relevant person? That's where it gets a little bit more complex. Well, there are two categories of relevant person. The first category is somebody who doesn't have leave to remain under Appendix EU, who hasn't had during the grace period such leave, and who immediately before 11 p.m. on the 31st of December 2020 was lawfully resident in the UK under the 2016 regs, or had a permanent right of residence under the 2016 regs. So already it's starting to get complicated. I flagged up a moment ago the first sort of temporal point, that to work out whether this category is subject to immigration control, you need to look at what they're doing now. But within this definition of relevant person, you can see under the third and fourth bullet point, we also have to look at what they were doing immediately before 11 p.m. 31st of December 2020. Were they lawfully in the UK under the 2016 regs? So as of 10:59 on the 31st of December, were they a worker? Were they a job seeker? So we have to look at their status at those 2 points in time to answer the ultimate question of whether they're subject to immigration control. So that is the first category of relevant person during the grace period. But we have an extension of that, which is that a relevant person is also a person who is a relevant family member of a person P, who immediately before 11 p.m. on the 31st of December didn't have leave under Appendix EU, but was lawfully resident here. So taking those two categories together, of those two categories of relevant person, what we're looking at is people who were lawfully here as of just before 11 p.m. on the 31st of December 2020, people who had a right under the 2016 regs and their close family members. So that, in simple terms, is what we mean when we say a relevant person. Now, I'm describing them as close family members because that's the vernacular that is used in the guidance, but relevant family member in this context is a term of art, and it is a complicated one. So a relevant family member of P includes somebody who's a family member within the meaning of Regulation 7.1.2 of the 2016 regs, and who was a family member immediately before 11 p.m. on the 31st of December. But it also includes children born or adopted after that date, with certain limited exceptions, as well as the durable partner of P. Any of those persons is a relevant family member of P. Now, there are the category of relevant family member, the people who fall within that. It's a slightly longer list than I've put on this slide. So you've got the reference to the statutory provisions at the bottom of the slide. If you're trying to work out whether somebody is a relevant family member, really you want that list in front of you, and you want to be going through and checking it off to see. But if you do have a relevant family member of a person P, then they are also a relevant person. So that is tremendously complicated. I know that. I think of all of the material I'm going to be covering, this is probably the most complicated category. So just to give you a worked example to try and put this in practice, let's say somebody turns up at your office. They are a French national who was working in a cafe for the last year or so. They haven't yet got themselves status under Appendix EU, and they are seeking homelessness assistance. So you've got to try and work out whether that person is eligible for assistance. Well, where I would start would be to work out, is this person a relevant person? So do they have leave to enter remain in the UK under Appendix EU? Well, no, that's the point. That's the premise of this scenario. Have they ever had leave? No. So then you have to work out what they were doing before 31st of December 2020. Well, I've told you that they've spent the last year or so working in a cafe. So you, from what I've said, it sounds like immediately before 11 p.m. on the 31st, they were a worker. They had a right of residence under the 2016 regs. So they are a relevant person. And as long as we are before the 30th of June, they are a relevant person during the grace period. So we're halfway there. So to work out whether they are subject to immigration control, we're then going back to the first slide in this section, and we are looking at what they are doing now. Well, are they still exercising a right under the 2016 regs? Well, as I've said, they're still working in their cafe, pandemic notwithstanding, so they are still a worker. So this means that not only are they a relevant person during the grace period, but they are exercising a right under the 2016 regs, so they are not subject to immigration control. Now, if the situation had been slightly different, if instead of that person approaching you, asking you to ascertain whether or not they're eligible for assistance, perhaps you had been approached by their partner, by their spouse, where you would go through exactly the same checklist. You would have gone through this checklist here to work out whether they're a relevant person, and you would have decided that the answer was no, but you would have then gone through the list to see if they were a relevant family member, and the answer to that would have been yes, because the person who they're a family member of is our individual who's working in the cafe, and we know that's somebody who meets those first two requirements. They didn't have leave to enter remain in the UK under Appendix EU of the immigration rules, but they were lawfully resident under the 2016 regs. So that's a worked example, which I hope gives you some idea of how this plays out in practice. So let's move on to our third category of person who is not subject to immigration control. And just to take a step back before I do, all we're doing so far, by way of reminder, is working out whether they're subject to immigration control. We haven't yet got on to actually working out if they're eligible for assistance. Adrian's going to help with that, but we're taking that preliminary stage. So we've covered two categories so far who are not subject to immigration control. The third refers to those who have made in-time applications which have not been determined by the end of the grace period. So for this cohort, Section 7 of the 1980 Act continues to apply during the relevant period. And so this applies to anyone who's made an in-time application and who immediately before 11 p.m. on the 31st of December was lawfully resident in the UK under the 2016 regs, or had a permanent right of residence. So you can see how this is the counterpart to the category we've previously considered. It's looking at people who were here lawfully doing an EU thing at 10:59 on the 31st of December, but it's extending it to the period beyond the grace period where those people have made in-time applications. So for this group, the 2016 regs continue to have effect, which means that if they are currently exercising a right to reside under the 2016 regs, so if they're currently a worker, self-employed person, for example, then they won't be subject to immigration control. So it's similar to the last category. Now, what is an in-time application? I think you could all got a sense of it just from the phrase. It is an application that is made in time, but it's a little more to it than that. It is an application for leave to remain under Appendix EU, which is valid, which is made on or before 30th of June 2021, and which has not been withdrawn. Now, in inquiring whether or not the application is valid, local authorities are not meant to be looking into the merits of the application. Whether it's valid has a specific meaning under Appendix EU, which relates to the procedural requirements. It's essentially, has it been done on the right form? Has the right ID been submitted? If you look at Rule EU 9 of Appendix EU, there is a short checklist of things that constitute a valid application. But what local authority is not meant to be doing is working out whether or not there's actually merit to the application. It's purely procedural point. So if those requirements are met, then it's an in-time application. And the relevant period, which is our next definition, begins at the end of the grace period, begins at the end of 30th of June 2021 and ends either when the applicant gets a positive decision granting them leave, or if they're refused leave and they don't appeal on the first point at which they are no longer entitled to appeal, so the point at which they are appeal rights exhausted, or if they're refused and they do appeal on the day on which the appeal is finally determined, withdrawn or abandoned. So what that does is it incorporates not just their initial right of appeal, but onward appeals. So this category is potentially the problematic one. If you found yourself, when I was describing the rules for category 2 for relevant persons during the grace period, if you found yourself switching off thinking this doesn't make any sense, I'm just going to bury my head in the sand until 30th of June 2021 until this all goes away, then this is the category you need to be worrying about, because what this does is it essentially prolongs the application of those rules for an indefinite period. You can continue to be a person not subject to immigration control within this category until your immigration appeal is finally determined. And we know that immigration decisions can take months, years, in some cases, to be made. And we also know that appeals can take months and years to be heard. So somebody who gets their application on the 29th of June, it may be years before it is finally determined. And throughout that period, if you're going to work out for homelessness eligibility purposes whether they are subject to immigration control, this is the category you need to be looking at. These are the rules you need to be looking at. So that is category 3. Category 4 I've described as a more self-contained category, and this is frontier workers. And I may be wrong, but I have a suspicion that this is not a group we're going to be seeing all that often in the homelessness context, because it applies to those who are EEA nationals, who are workers, but who aren't primarily resident in the UK. It's people who are primarily living abroad, but who are working and have a right to work in this country. And I think that sort of globe-trotting worker is perhaps not typical of the homeless applicants who we typically represent. Nevertheless, they have a right to access services. That is part of the rights they have as frontier workers. And so the statutory instrument which is specifically targeted at this group, Regulation 5.1 of the Citizens' Right Frontier Workers Regulations, provide that they are not subject to immigration control. So what does primarily resident mean for these purposes? Under the regulations, you're not primarily resident if you've been present in the UK for less than 180 days in the 12-month period immediately before that day, or if you've returned to your country of residence at least once in the 6-month period immediately beforehand, or twice in the 12-month period. So Frontier workers, then, just to recap that, are EEA nationals not primarily resident who are workers, self-employed, or have retained worker or self-employed status under the citizens' rights regulations. Now, I think those of you who've delved into this area of law will all have been familiar with the notion of retained worker status under the 2016 regulations. Retained worker status under the Citizens' Rights Frontier Workers Regulations is the equivalent status for those who are frontier workers. So those are our 4 categories of persons subject to immigration control. If you've gone through all of this and you've decided that your EEA national is not a person who is subject to immigration control, they don't fall within any of those 4 categories, then they are going to fall with, if we're to decide whether they're eligible for homelessness assistance, we need to show that they fall within Regulation 5 of the 2006 regulations. I'll go through Regulation 5 fairly quickly because I'm hoping for most of you this is going to be more familiar territory and less complex. So particularly the first few classes, they've been unamended for some considerable time, and we're used to them. So Class A is refugees. Class B is those with exceptional leave to remain granted outside of the rules, not subject to a no recourse to public funds requirement. Just a quick note on that category: exceptional leave to remain used to be a term of art. It was abolished in 2003. So now we construe that category as referring to anybody who is granted leave exceptionally outside of the framework of the immigration rules. But importantly, it's those who are subject to a no recourse to public funds requirement. So in human terms, this will often apply to people who've applied under Appendix FM of the immigration rules, and it's been decided that they don't qualify under Appendix FM, but nevertheless they have Article 8 rights which warrant them being granted leave outside of the rules. So that's B. Class C, indefinite leave to remain. That is one of our more straightforward categories, but very important to flag here. This is the category in which EEA nationals who are granted settled status now fall within. So pre-settled status is not indefinite leave to remain, so that's why those with pre-settled status are dealt with differently. But if you have settled status, it is in a form of indefinite leave. So anyone with settled status is subject to immigration control, but they would fall within Class C. Class D, humanitarian protection, fairly clear category. Class F is one of the more esoteric categories. This refers to certain Afghan citizens who were working with the MOD. I think it was the Afghan interpreters class. Class G is an increasingly common category of those who've been granted leave under Article 8 leave under Appendix FM of the immigration rules, or the associated rules within the main body of the immigration rules, who is not subject to a no recourse to public funds requirement. Now, the default position when you're granted leave under Appendix FM is that you are subject to a no recourse requirement. So if you have a destitute homeless client who has a leave under Appendix FM and they're subject to an NRPF requirement, the first thing you need to do if you're going to be trying to get them homeless assistance is to get that NRPF requirement lifted, is to be liaising with the Home Office to show that they are destitute, and that requirement should be lifted so that they can then bring themselves within Class G. Classes H and I have some similarities to each other. Section 67 of the 2016 Immigration Act is the Dubs Amendment, which was an amendment to the Immigration Act introduced by Lord Dubs with a view to bringing unaccompanied asylum-seeking children from Europe to the UK. Class I, Calais leave, refers to young people who were brought to the UK in connection with the clearing of the Calais refugee camp in, I think, the period 2016 to 2017. So those are niche but important categories. Bear in mind with those two categories that there is a reasonable likelihood that the young person you're dealing with will have been looked after by social services. So as well as having a route to eligibility because of their status, it may well be that they have a priority need because of their experiences, because of the fact they've been looked after. Class J, just 2 more categories and then I'll finish up and hand over to Adrian. Class J is a more complex and new category, which one of the new categories that was introduced in August last year. It refers to a person who's limited leave to remain by virtue of Appendix EU, where they're the family member of a relevant person in Northern Ireland, and they would have been eligible under Reg 62D, which provides exceptions to the habitual residence test. I think that Adrian may be coming back to, if the relevant person were a worker or a self-employed person or treated as such under the Croatian accession regulations. And a relevant person of Northern Ireland means a British and or Irish citizen born in Northern Ireland to a British and or Irish parent, or to a parent entitled to reside in Northern Ireland without any restriction. Now, this is a tortuous category. It's another one I don't think we're going to be applying very much, but just to give you sort of the political background to understand what this is directed at, it is a way of recognizing rights under the Good Friday Agreement. It is a recognition of the fact that those born in Northern Ireland should, under the Good Friday Agreement, have the right to identify as they so wish, whether that as a British citizen or as an Irish citizen. And if they are to identify as an Irish citizen, then their family members should have the same rights as other EEA national family members. And so the eligibility rules were changed to reflect that, and the rationale was that those in this position who wish to identify in accordance with their rights under the Good Friday Agreement as an Irish citizen, they shouldn't be feel any incentive to renounce their British citizenship. So that it's ensuring that those who have those rights, who are born in Northern Ireland, have parity with Irish nationals, and so have the same rights. So that is the penultimate category. Our final category is Class K, which is those who've been granted limited leave to remain on the basis that they are stateless. So that brings me to an end and concludes what I have to say about Regulation 5. I'm going to hand over to Adrian now to pick up the baton.
Thank you. I'm just going to share my screen, or that portion of it which bears on our task today. I hope you have that. You can see the slides, and I'm going to talk about how it all fits together in terms of where we go with eligibility regulations in relation to other persons from abroad. So in a sense, I'm dealing with people who are not persons subject to immigration control, and not people who are, or people subject to immigration control who are treated as if they're not. So it's a slightly odd thing. And in immigration law, it makes a big difference in terms of how you are controlled by the state. In the terms of social welfare, it's about the distribution of responsibility. Generally, persons from abroad have rights on some other basis rather than requiring permission from the Secretary of State to be here, from the Home Secretary to be here. And so that's the sort of idea that you know, you might be a British citizen, or you might be Irish, or you might have a withdrawal agreement right under the EU withdrawal agreement, and so on and so forth. And so the idea is that your root of entitlement is based on a right rather than a grant of permission to be here. And so as we're all very familiar, the allocation and eligibility regulations bifurcate the categories of eligible persons into those subject to control and other persons from abroad. And so the latter category is my task today, to fit in certain people from Connor's presentation, and to add others who are also entitled. So the backstory, of course, is that we could just be repeating a seminar on eligibility under the homelessness regulations on the categories. But the great backstory is really the withdrawal agreement and the way in which it's been transposed and implemented in our domestic law as a result of Brexit. In and among that, there have been some renovations in the light of the Good Friday Agreement, as Connor mentioned, but as the Good Friday Agreement obligations understood in the light of Brexit. And so that's how, and of the withdrawal agreement and the Northern Ireland Protocol. So we really have to fit all of those things together. The regulations are much amended, and they're amended in a way which is extremely unhelpful, because they refer out not only to the General Governing Act, the Housing Act 1996, as they always did, but now also to other Brexit-related statutory instruments. And the one which contains provisions which have to be read with it, as we've already been introduced to, are the Immigration and Social Security Coordination EU Withdrawal Act 2020, Consequential Saving, Transitional and Transitory Provisions regulations, which are the main regulations that implement the Immigration and Social Security EU Withdrawal Act. So you have to have Schedule 4 of that statutory instrument by your side, because of course the default position is that the Immigration and Social Security Act repealed free movement, and in so doing repealed the Immigration European Economic Area regulations, which are the main way of transposing free movement rights into our domestic law. So we have stuff left over. We have amendments to the allocation of housing and homelessness regulations, and we have bits of the Immigration European Economic Area regulations, but only for certain purposes, for welfare benefits, and also for allocation of housing and homelessness purposes. And the bits that remain form a discrete code for these purposes and in terms of our domestic law. And so it would have been very nice to have the equivalent of a Keeling schedule, which set out the Immigration European Economic Area regulations as they apply in homelessness. And you might have to make your own as a result of working your way through the Schedule 4 to this statutory instrument, the Immigration and Social Security Commencement Statutory Instrument. But we are where we are with that. And one point I would make at the outset about that is that that statutory instrument, the Immigration European Economic Area regulations, the bits of it which still apply in homelessness, still has the backstory of having to be consistent with the requirements of EU law as they were frozen in time at the end of the Brexit transition period, at the end of at 11 p.m. on the 31st of December, just gone. So that's our jumping off point. And so we also have these definitions for our purposes of job seeker, employed person, and worker. And they have the amendments, they take their colour from the EEA regulations as they're amended and saved under Schedule 4 of the Immigration and Social Security Commencement Regulation. And so what we have are those terms, but they also are to be defined as the terms that they meant in EU law right at the end of the transition period at 11 p.m. under the case law on New Year's Eve. So whatever the term worker meant in EU law at 11 p.m. on the 31st of December is what it means in terms of its width and its scope as it's to be applied for these provisions for homelessness. And you might think, well, what does that matter? It's like, it's all about retained worker status, that when you leave, when you lose your job, can you retain worker status and therefore be eligible? And so that particular case law remains important. And so we find other definitional terms in the regulations, definition of frontier worker, which I'll touch on hereafter. Obviously, frontier workers, it didn't matter before Brexit, you could just come and go when you pleased. But now that we're not in the EU and the transition period is over, those people that do live in one country to which they return periodically but work in the UK need to have permission to do so if they've already been doing that before the end of the transition period. So we have frontier workers. And then we have definitions of family members for these purposes. And remember that family member doesn't include extended family members who would get grants of permission under the old regime, under the free movement regime, because they were aunts or uncles, cousins, nephews and nieces and so on. It includes direct family members, your children, your grandchildren, parents or grandparents, you know, and so on and so forth. So that's where we start. And then we get into the overarching framework, the architecture, if you like, of other persons from abroad who are not subject to control. How do they fit in? How are they eligible? And in understanding how the withdrawal agreement classes of people fit into it, the classes of people that Connor touched on, people who have withdrawal agreement rights, either as settled status persons with indefinite leave by reference to the withdrawal agreement, or pre-settled status, limited leave under the, by reference to the withdrawal agreement. They fit into the overall architecture. The general rule for other persons from abroad is that you're excluded unless you're included, and that you must be habitually resident unless you belong to a class of persons relieved of that obligation. So we have habitual residence, as we know, looking at the period of time you'll be here and the intentions that you have for being here, or habitually resident in other parts of the common travel area, Ireland, the Channel Islands, or the Isle of Man. You can't have solely a right to reside as a job seeker, a family member of a job seeker, a person with an initial right of residence, or as a Zambrano primary carer. Now, all of this, of course, relates to the law prior to the end of the transition period, prior to the end of last year. But it continues to be relevant insofar as it applies to people with pre-settled status. And so this sort of law, looking at if you're doing an underlying EU thing, continues to be relevant. Now, we know that Zambrano carers are excluded from these provisions, but imagine, and just put this there for consideration, we can pick it up later on, that there might be circumstances in which people who qualify under this provision, not as the people with excluded rights to reside, but on the basis in the penultimate bullet point on the slide that you're looking at, if they had those sorts of statuses, the EU statuses, prior to the end of the transition period, or they have it during the transition period and in the grace period, they still continue to qualify under the grace period regulations. So let's look at this in stages. There's a class of rights to reside that never count for the purposes of eligibility for homelessness assistance: job seeker, family member of a job seeker, person with the initial right of residence, and so on and so forth, and particularly Zambrano carers, the primary carers, third country national primary carers, third country national meaning during the time we were in the EU legal order and not a citizen of an EU state. Who is included? Well, obviously, those people who are included who are subject to the habitual residence test include, and we shouldn't forget, British citizens, Irish citizens in that status, persons exempt from immigration control, which doesn't just apply to diplomats and consular officers, but people who work for international organizations who have immunity from jurisdiction, and also Commonwealth citizens with the right of abode. Now, obviously, there are a lot of Commonwealth countries and a lot of Commonwealth citizens, but there we're just dealing with people who were born prior to 1983, where they have a UK-born mother, basically, for reasons we don't have to go into. If they'd had a UK-born father and they were born prior to 1983, they'd be British citizens today. So the easy way to remember that is you're born prior to 1983 in Australia, your mum's born in the UK, you'll be a Commonwealth citizen with the right of abode. That's how that works. And then about a batch of EU rights to reside where you're not exempt from the other elements of the habitual residence test. So the student right to reside, the right to reside as a self-sufficient person, retained rights, or permanent residence obtained after 5 years. Now, all of that applies to the cohorts of people who might have pre-settled status by grant or be in the grace period and not yet have secured documents under Appendix EU to the immigration rules by virtue of pre-settled status or settled status. So, so the continuing relevance of these categories is that they continue to be relevant to understanding that cohort of people with pre-settled status who might be eligible for homelessness assistance because they continue to be doing an EU law thing, so to speak. So we have to have a bit of thinking about that in relation to the grace period cohort and in relation to the pre-settled status community, because the thing about Appendix EU to the immigration rules and pre-settled status and settled status is it's broader in who it benefits than the withdrawal agreement rights. So under the withdrawal agreement, if you want to have continuity of EU rights, and you were here before the end of the transition period, before the end of last year, you have to have been doing an EU thing. You have to be a worker, a self-employed, self-sufficient, family member of such a person, and so on. That's how the EU negotiated it with the UK. When it came to the UK under the settled status scheme, they said, well, you know, we're going to grant leave to anybody who's been present here. And if you've been present here, who's an EU citizen, effectively. And if you've been here for 5 years or more, you get settled status, indefinite leave to remain. And if you've been here for less than 5 years, pre-settled status. So they didn't look and they didn't inquire into into what you were doing, whether you were doing an EU law thing. Appendix EU is possibly the worst piece of public policy drafting ever to have emanated from Whitehall and Westminster, and that's up against some pretty stiff competition, as you can imagine. But one thing it doesn't do is impose EU rights to reside on tests in order to grant status. And what settled status is really just branding. What you actually get is either limited leave under the 71 Immigration Act or indefinite leave by reference to these presence-based criteria. So it doesn't matter if you've got indefinite leave, if you've got settled status, because you can't impose restrictions or conditions under the Immigration Acts on people with indefinite leave. But with the pre-settled status cohort, you can. And so the question then is, which of those people are entitled to equal treatment under the withdrawal agreement so that they must be eligible for homelessness assistance? And the answer to that question is those that were doing an EU thing or are doing an EU thing, such as being a worker, student, self-sufficient, having a permanent right of residence, and so forth. So we have to subdivide the pre-settled status cohort into those that benefit from these provisions. And so, and of course, some people luck out twice over. Not only are they eligible under being other persons from abroad, but they're also relieved from the habitual residence test. And so that privileged cohort includes, and I'm using this term as it applies during the grace period and for those that have pre-settled status, workers, the self-employed, the family members of such persons, people who got the EU right of residence by reference to EU law in less than 5 years, and so on. So although all of this general rubric ended on New Year's Eve, just gone, it still applies to people with pre-settled status and those who have grace period protections. And so we still have to use it for those purposes. And then, of course, the other persons from abroad who are relieved from the from the need to satisfy the elements of the habitual residence test are those who've been deported back to the UK, who have British citizens expelled from other people's countries, frontier workers, and the family members of frontier workers granted limited leave. Now, we're not here on immigration law today, but frontier workers have a privileged status. They don't need a document to prove they are frontier workers. They have a right to apply for one and be granted one if they want one. So they still get what we used to think of in old school terms as registration certificates. And they don't need a grant of leave. They get a certificate recognizing they have a right to reside. So that's why they're not, that's why they're in Regulation 6. And then their family members have got family reunion rights. Now, you might think frontier workers, they're all kind of, they're bankers, or kind of, they're the sort of people like lawyers, they just fly around from Zurich to London managing their clients' offshore accounts. But in fact, think about the haulage industry. Think about people that drive lorries back and forth, bringing goods in and out of the UK, through the Channel Tunnel, through the port of Calais, through the port of Harwich on the way to Holland. There are, in fact, quite a lot of frontier workers who are on modest incomes and not bankers and not people who are working in highly paid professions. And so they will often reside in the UK for temporary periods of time and return to their home countries. And more importantly, their family members have full rights of residence in the UK. So when they get limited leave to remain, or indefinite leave, ultimately, potentially under the immigration rules, then they also qualify for homelessness assistance. So you might find that people are applying as homeless, particularly in the southeast of England and in the London region and in East Anglia, where the ports generally are that go to continental Europe. So there are things there that we need to think about. Now, in terms of the cohorts of people who come within it, as Connor's already touched on, we have members of this so-called post-transition period group, which sounds awfully grand, that you have limited leave to enter or remain. So we're talking about their people with pre-settled status. That means they get the opportunity to demonstrate as other persons from abroad that they're doing an EU thing. If you've been granted limited leave to remain or leave to enter, because you've not been here for 5 years, so you haven't got permanent settled status or indefinite leave, you're in that cohort of people. You've then got to show up and say, well, I've got this, but that alone is not good enough. I'm also doing the underlying EU thing, or I'm in the grace period and I can show I haven't yet got this limited leave, but I'm in the grace period. So equivalent to this group of people are people in the grace period who have also doing the underlying EU thing. Then you have a modified regime, as we've already touched on, of the Immigration European Economic Area regulations, as they have effect immediately before they were revoked, but subject to the modifications made by Schedule 4 to the Immigration and Social Security consequential regulations. So we've got a modified regime, and you've got a code there for applying that. And then underpinning that is the need to give effect to the idea that these rights to reside continue effectively to subsist and be available to those who either who fall within the pre-settled status cohort. And so what they've had to do is a bit of statutory wheedling, and it's not entirely clear whether they've been wholly successful in the drafting of this. But parking that point for the moment, you'll see that the intention in the long title of this particular provision of Schedule 4 is for the continued application of Section 7 of the 88 Immigration Act for housing legislation purposes. And what that means in practice is that you don't need leave. If you had an underlying EU right, you can continue to rely on that for the purposes of establishing your entitlement to home eligibility for homelessness and an allocation of social housing. So if you've got pre-settled status and you're doing an underlying EU thing, then you get to the point where you can benefit from that. And then the second group, as they fit into this, are those people who qualify in the grace period, and Connor's already gone through who the relevant persons are for that. One of the curious things about the withdrawal agreement is, generally speaking, you have to have been here or doing something here prior to the end of the Brexit transition period, so prior to the end of New Year's Eve. But in addition to that, there are some family members who can come for the first time after the end of the transition period, so long as the principal EU citizen is here before the end of the transition period. And so the grace period regulations have to cater for both those cohorts of people, and these are people who are not documented either because they're here before the transition period, so they've got until the 30th of June, or they come subsequently. So that's how we have to look at that. And so, and again, the grace period regulations, these regulations, as they're sort of collectively known as the grace period regulations, they also contain their own code of an adapted version of the Immigration European Economic Area regulations, which applies for these purposes. So it is a bit fiddly. I mean, there's no doubt about it. I mean, particularly when you have joining family members who are coming for the first time after that. And of course, you know, somebody who's got a withdrawal agreement right, who's here prior to the end of the transition period, they could have a child born to them outside the UK in another EU state or elsewhere in a couple of years' time, and that child could qualify to come to the UK under the withdrawal agreement provisions. And so this question of people coming, people joining, people turning up later on will continue to subsist for quite some time. It's not something that's time limited. And the grace period regulations and the like, and the provisions in Appendix EU to the immigration rules cater for that. So in practical terms, when you're dealing with a homelessness application, you're always looking, it might affect not so much who is the principal person, but who is the family member that might trigger the priority need obligation. And there might be a family member who's not hitherto been considered or not hitherto been documented, who you might be able to embrace within the application because they're lawfully here under the grace period regulations. And so that would make a big difference to those persons. Continuity of residence is a very important category here, because if you had now under the withdrawal agreement, you could be away for up to 5 years and not lose the right of permanent residence. Prior to, under EU law, free movement provisions, 2 years was only permitted. So there are some people that now are able to re-enter with the right of permanent residence under the withdrawal agreement provisions. And that can trigger, of course, family reunion rights as well. So one of the things you need to do is, you know, I mean, there's no sort of two ways about it. There's no getting away from this, in the sense that you have to be pretty adept at immigration law in this field to understand the full plenitude of the rights that your client may have, or take advice on that, because it is going to be very, very fiddly. My concern is that at the front end, in a homeless persons unit and among decision makers, that this law is so complex at this stage that it lacks the qualities of transparency necessary for legal certainty, for good administration, and for being accessible to people upon whom it devolves. And so there is an element of all of this at which if we thought eligibility was a chewy area beforehand, you know, it's worse by multiple orders of magnitude as a result of of what we've seen. And the grace period regulations also embraces and adapts Section 7 of the 88 Immigration Act, as we've seen before, as applied in the to the post-transition cohort, people who had pre-settled status. So too, similar adaptations are made for the purposes of the grace period cohort. All of that underpinning is important. Kind of touched on the fact that the grace period can extend beyond the 30th of June, not just for new arrivals, but obviously who enjoy family reunion rights under the withdrawal agreement, but also, in effect, we have the situation where people who've made an application for leave that's under the settled status scheme, which remains undetermined, or they're within the time for appealing a refusal, or they're bringing an appeal against a refusal, can continue to enjoy the protection here. That's because the withdrawal, that's not because the government have had an outbreak of generosity in this area, it's because the withdrawal agreement requires them to do that, sort of line by line. And so immigration appeals do take a while, and it's not unknown for them to last more years. But the point is that you will continue to be eligible if you can show the underlying entitlement to the HPU. You don't have to rely on the immigration decision as to whether or not leave is granted while your appeal is pending. You may be able to persuade an HPU or on review, a local authority, or on review, a local authority, or an appeal, a judge, that you are eligible for assistance directly without waiting for the outcome of that. And so it's a bit like having able to rely on EU rights directly in old school eligibility cases prior to the end of the transition period without having a registration certificate or an EA residence card to prove status. And it's a similar sort of thing. So the fact that it goes on for a while doesn't really trouble me so much. There's a source of comfort to some extent that you might be able to be housed while the Home Office take their time and delay on making a decision on your case. Because one of the things that we do know is that from this point forward is that the Home Office have given settled status or pre-settled status to all the easy ones, all the, worked for 5 years, or been present in the UK for 5 years. That's sort of straightforward and easy. It'll be the family members, the third country national family members of EU citizens who have complicated applications, possibly on retained rights of residence basis and the like, who are going to be in more difficulty. And not for the first time, EU beneficiaries of EU law who are third country nationals, who perhaps come from backgrounds which are whose heritage lies outside of the European continent, they will find that they are the difficult cases, and they are often the people who are most vulnerable to the consequences of a refusal or of a delay in the processing of their immigration application at a time when they need housing assistance. So we're likely to find that those are important. I'm going to mention frontier workers already in our presentation, and Connor's mentioned them as well. So I'm not going to go back on that, other than to bear in mind that this is an important category. And also you could be self-employed in a frontier worker as well, which is not widely appreciated. The term worker often intends to imply that there's some employment contractual relationship. Bear in mind, the interesting thing about frontier workers as well is that concept of retained worker status or retained self-employed status, when you're no longer working, say because you're temporarily unable to work as a result of illness or accident, or you've been made unemployed. That applies too to frontier workers. So the fact that someone is a frontier worker and they're not actually working, which might seem a little bit counterintuitive, doesn't matter if they've got retained worker status, retained frontier worker status, if you like. So that's important too, that if you do have people that work in those sorts of industries, to keep an eye on that. And a bit of law here, just on generally, which applies in this area. And it's this, is that citizens' rights under Part 2 of the Withdrawal Agreement are a separate set of rights to the general provisions that the UK has made for downloading and retaining EU law under the European Union Withdrawal Act of 2018, as amended by the 2020 European Union EU Withdrawal Agreement Act. And so they are subject to separate provisions. The rights which apply are those which are directly justiciable in our courts before public authorities, whether they're administrative or judicial, by Section 7B of the European Union Withdrawal Act of 2018. And the case law to be applied, as you can see from Article 4 on the slide, is EU law interpreted in conformity with the case law of the Court of Justice handed down before the end of the transition period. So this ties back and loops back to my point that, if you're looking at who is a worker, who is self-employed, what is the scope of the term family member, who has retained worker status, on what basis may I be a family member, all of those questions, you look at the jurisprudence of the Court of Justice as it stood at 11 p.m. on the 31st of December. So there's, if you like, withdrawal agreement case law, withdrawal agreement law, applying all the concepts of EU law as it applied at the moment that we left. And it's different, if you like, from retained EU law. And the reason I mention that is that there's a whole batch, as you will all be aware, of provisions that allow ministers to adapt, modify, restrict, and omit provisions of retained EU law as it applies generally. So we're gradually going to see greater and greater deformation of the retained EU law statute book as it gets more and more manipulated in the interest of adapting it to a post-Brexit environment. You can't do that with citizens' rights withdrawal agreement EU law. It's as it stands and not to be adapted. So the difference between retained EU law for other purposes and citizens' rights withdrawal agreement EU law is that the latter is frozen. And will not be subject to modification because it relates to rights. And that includes, and I mentioned this again, the general principles of EU law, which include the principle of proportionality as opposed in terms of recognizing rights of residence. So those sorts of things are interpreting rights of residence. So that's a very important point to bear in mind. That a lot of the toolkit, don't forget all your EU law simply because of Brexit. So it's going to continue to apply in this field. And then I want to touch on this provision as well, because it has been adapted as a result of our exit from the European Union. And there's a healthy debate on what this provision means. And it's section 1854 and 5 of the part 7 of the Housing Act. And it deals with the sorts of people who have to be disregarded for the purposes of a principal person's question of whether a principal person is homeless or it's a priority need for accommodation. So who's in their household that might trigger whether they are homeless or whether they're in priority need, and therefore the level of obligation owed to them. And it became apparent a long time ago that this question was could you take into account dependent children who didn't have any immigration status? And there was a case about a British citizen who had a child who was subject to immigration control and who lacked immigration status. And it was Westminster City Council against Morris, which was all the way back in 2005 in the Court of Appeal. As a result of it being found to be discriminatory as contrary to Article 14 of the Convention on Human Rights, this provision was adapted in its original form. And what they did was they restricted it so that the children of people who were, if the principal person was a British citizen or an EEA national, then their children could be taken into account for the purposes of dependent family members for the purposes of deciding whether they were homeless or in priority need. But if they were third country national, this is the pre-amendment situation, their children were excluded from that kind of consideration. So you have to look at the situation. The child has an irregular immigration status that wouldn't qualify. The question then is, can the principal applicant be excluded? Can the principal applicant take that child into consideration in order to show that he or she is homeless or in priority need? And if you had a British citizen parent, the result of the Morris judgment was that you could take that child into account. And because of the then existing EU law, you had to afford equal treatment as between the British citizen and the EEA national. So the EEA national's irregular status child, so third country national child, could also be taken into account for the purposes of priority need or homeless, or deciding whether a person is homeless. How does Brexit change that situation? This is what this amendment in sub-regulation and sub 5 is concerned with. And what it's saying is effectively that if you're the principal person and you fall within the classes of, you're a person subject to immigration control, and so you fall within in one of those classes that Connor mentioned, A, B, C, D, so on and so forth, that generally speaking, your dependents will be disregarded if they're ineligible for the purposes of homelessness or priority. And that will now extend to people who have EU citizens who have leave to enter or remain, except that if you were here before the end of the Brexit transition period, IP completion day, then you are and you were an EU national or a national of an EEA state, right? So that includes Norway, Iceland and Liechtenstein or Switzerland, and within such a class, you continue to be able to have your children taken into account. So in other words, because those people still benefit from the equal treatment provisions of EU law effectively, as it's preserved under the Withdrawal Agreement. So from this point forward, British citizens, for example, can have their dependents taken and members of their household taken into account for the purposes of homelessness and priority need. And those EU nationals of an EEA state or Switzerland who fell within, who had, say, ILR before, for example, before IP completion day, can also have their children taken into account for the purposes of homelessness or priority need. But other than that, if you're an EA national or a Swiss national, or indeed a third country national of any description, you cannot have your children or dependent members of your household taken into account for the purposes of homelessness or priority need. So it's an attempt to preserve the equal treatment given to the principal EEA nationals prior to the end of the transition period, in order to reflect the initial adjustment that was made following the case of Morris, to limit the exclusion to the children of third country nationals. And so, of course, third country nationals from this point forward, from the IP completion day onwards, includes EU citizens. So it's not hugely satisfactory, and it's not entirely clear whether it's consistent with the provisions of the Withdrawal Agreement. I just put that marker down in relation to people that might, but it's what they're trying to achieve. Whether or not they've achieved it is a different question. But that seems to be the ambition, is to adapt the post-Morris adaptation to the post-Brexit environment. So there's that. And then finally, don't forget Schedule 3 of the Nationality, Immigration and Asylum Act, our friend, for excluding people, that provisions to exclude people hitherto unexcluded by any other provision of the statute book. Bear in mind that it applies, although it might be seen to be more theoretical than real in some cases, to interim accommodation pending review and pending appeal under Part 7 of the 96 Act. The adjustments which have been made at the end of the transition period as a result of Brexit are to remove mere EEA nationality or being a dependent of an EEA national from the categories of people who are ipso facto automatically excluded. And therefore also to remove the idea that you can overreach the exclusion by reference to EU law. From this point forward, there's no automatic exclusion from by Schedule 3, either to the interim accommodation provisions of the Housing Act or to the other range of community care and local authority and NHS provisions, which are excluded by paragraph 1 of this schedule. Why does this matter? Because, for example, if you had an excluded right as an EEA national, for example, as a job seeker or as a person, or potentially you could go, you were an EEA national, you might be eligible for some of the other forms of community care, for example. So hitherto, a job seeker who, say, was a German national or a Romanian national or something would be excluded by being an EEA national. But if they have a job seeker, they would have had a right to reside. So you might now have a job seeker with pre-settled status who is excluded from the homelessness provisions, but eligible for local authority community care or some other form of provision that's provided for under the general rubric of local authority powers or NHS powers. And they no longer automatically excluded by Schedule 3, nor are they a person unlawfully in the United Kingdom because they're a job seeker, either with pre-settled status or with grace period protection. So they might now be able to turn to the other provisions which are excluded in paragraph 1, when they would not have been able to do so before, if to refuse them community care or NHS care or some other local authority help would be a breach of their Human Rights Convention rights. And so in some senses, it opens a door, a chink, not very much and not very widely, but the door is open as a result of that. And it's a microscopic gain potentially. So I mention it because if we don't get what you want from part 7, there may be new horizons opening up ever so faintly under these provisions. So yeah, that's how that works. Thank you very much. That's that. So I think we've got time for questions now as well. I'm going to stop sharing so that we can all see each other as well.
Thank you for that, Adrian. And thank you, Connor, also. I think everyone will agree that both of those presentations were exceptionally clear and detailed. And of course, all of those presentation slides will be circulated at some point after the end of this webinar. Now, at the moment, we don't have any questions in the Q&A. So now is your opportunity to type some questions in there if you do indeed have any. I know that probably for a lot of us, it'll take some time for this information to percolate a little, but I should probably wait a few more seconds to see if there are any questions.
While we're waiting for questions, Angharad, perhaps if I could just have a bit of a moan, which I didn't take advantage of while I was giving my presentation, is it will be obvious from everything that Adrian and I have said that this is really, really complicated. And I'm sure some of you already will have had a look at the amended chapter 7 of the Code of Guidance to see whether it helps you make any sense of the stuff we've been talking about tonight. And from my point of view, it doesn't. The new guidance is so general and vague as to be of virtually no assistance at all. It just doesn't do justice to the complexity. It says things like, if you are an EU national, an EEA national who is eligible, who is able to apply for leave to remain under Appendix EU, then you will be eligible if you satisfy the eligibility criteria. It does nothing to explain what those eligibility criteria are. There was also, some of you may have seen a letter to local housing authorities, chief executives, published in late November last year, sent by Ministry of Housing, Communities and Local Government, which is meant to explain these changes. And it does virtually the same thing. It has a flow chart to try and help you work out who is eligible and who it wasn't. And it just doesn't go into the detail. So it is a difficult task that we have ahead of each other. I don't generally plug the homelessness book I write with Liz and Tessa in these things, but I'm going to now. We are working on updating this at the moment. We hopefully should have a copy out fairly soon, which I hope will try to explain these things clearly. But at the moment, the guidance, the help we have from central government to get our heads around this isn't really up to scratch.
Thank you for that, Connor. And I think that also answers a question that's appeared in the chat. We have another question in the Q&A here, which is from Amy Clements. And the question is, a person who has applied for settled status and has clear 5 years residence to be granted that, who has not yet made or is awaiting the outcome of their settled status application, will they still need to have an underlying right to reside to be eligible for assistance? Perhaps, Adrian, you might be able to assist us with that.
The answer is that is a risk category for not being qualifying, because there's no determination of the fact that they are eligible for settled status. They've averred it, and so the question is that you need to, in the grace period, you need to be showing you're doing an underlying thing if it's not been granted. So it has it's a difficult one, because it's the way you tend to do is you apply for status, and then the Home Office will often grant you pre-settled status rather than settled status, having examined the situation. And of course, the trick, settled status is indefinite leave, and the reason there aren't conditions imposed upon it is once it's granted, you cannot impose conditions on indefinite leave. Section 3 of the 71 Immigration Act doesn't allow you to do that. But prior to that, it's a question of understanding if you don't have it, then obviously now we're in the grace period regulations apply.
Thank you for that. We have another question. My concern is what the approach will be for family members who may or may not cease to be family members due to a relationship breakdown or DV, as well as clients who cease to be able to work due to mental health difficulties, which are potentially long-term and indefinite. Again, do either of you, Adrian or Connor, have any guidance in terms of how those categories of people might be treated?
Connor, I don't know if you want to go or you want me to have a go.
I'm mulling that one over, Adrian. If you want to start, perhaps I can pick up.
Sure. Yeah, no, sure. I mean, again, I mean, obviously we're talking here about people that won't have been granted status. And so because if you have, then the question is whether you're doing the underlying thing. There are provisions in EU law as it's retained during the grace period for a retained form of status, and when you cease to be a family member in certain situations, on divorce, death, or departure, for example. Domestic violence reasons enter into the fray in certain situations. If you're still married or in a civil partnership, if that's applicable, then of course the rights can be relied on under during the grace period. The difficulty is always proving it, because of course you don't want to have it's a matter of evidence, because you have to prove that the principal person is doing something in the UK. Retained status for family members during the grace period, you would have to prove the underlying entitlement, and that's again a question of evidence. So there's never been very good protection for survivors and victims of domestic violence in retained family status in EU law. But whatever there is continues to need to be proved as a matter of evidence during the grace period in order to have the entitlements.
Thank you. I might just extend that question just to clarify what will happen to people in that situation after the end of the grace period.
They will need to have applied before the end of the grace period to get grace period protection. If you haven't applied by the end of the grace period and you're not a new arrival in the UK, you know, joining a family reunion provision providing for that, then you have nothing, no protection, no eligibility until grant of status. And the difficulty with that is that you then have to, the pressure then gets, if you want assistance, social welfare assistance of any kind, you have to get that decision made. And so the pressure is you then have to judicially review the Home Office for delaying any application for pre-settled status or for sitting on it. And of course, part of the Home Office consideration will be whether or not you have a reason that they consider sufficient to exercise discretion to consider your application late. So it will resolve itself into the focus of attention being on the immigration application rather than on the welfare application.
Thank you for that. The next question is, if you were physically present but not lawfully on the 31st of December 2020, i.e. you were an EEA national but not exercising treaty rights, but have not yet been here for 5 years, are you stuck for eligibility for the remaining period until you get your grant of permanent settled status? And I'm going to pass that one to Connor.
Yes, is the short answer. I mean, if you haven't yet got your pre-settled status, then you're not in the pre-transition group, so you don't become a person not subject to immigration control by that means. To get in the second or third categories of persons not subject to immigration control, then it mattered what you were doing on the 31st of December. So if you were present but not lawfully here on that day, if you weren't exercising your treaty rights, then you are going to be subject to immigration control. So until you get some sort of so the question would then be whether you fall into Regulation 5, and the answer would be no. So until you get your status, whether it's pre-settled status or settled status, you're not going to be eligible. And also just to add to that, if it's pre-settled status that you do get in due course, then to be eligible, you're also going to have to show that you are doing a relevant EU thing right now to get in with Reg 6, so that you're a worker now, self-sufficient, self-employed person now, that kind of thing.
Thank you for that.
Bear in mind that a person may be treated as being unlawfully here, but turn out not to be, because once you become a family member, as a matter of law of any principal EU person doing something, you will become lawfully here. And so there's often a great deal of misapprehension of someone who's entered unlawfully the UK or has overstayed a visa might turn out to be lawfully here after all, because they end up being, on closer examination, a family member of a principal EU person. So there's an evidence question about how true these things are, in terms of that status. Often people here with family members here often find that things are better off than they thought they were in terms of creating eligibility.
The next question is there any case law which sheds light on cohabitees and unmarried partners being treated as family members who recently got into a relationship with somebody with settled status 2 weeks ago. This is, I think this is setting out here the specifics, but perhaps the question is just what I've said. Can I pose that to Connor, please?
Any case law which sheds light on cohabitees or unmarried partners? I'm probably not the best person to ask for that one. Is that something you can field, Adrian?
Under the settled status scheme, there's no, I mean, case law on the settled status scheme is sort of exiguous when there's barely anything. I mean, there is case law obviously on what cohabitation means in terms of the durable partner rule, because there's a question about whether or not the extent to which other provisions of EU law apply, but there isn't anything specifically in relation to the settled status scheme.
Thank you, Adrian.
I mean, I should say that the settled status scheme is, if any time you think it's badly drafted or incorrect in terms of withdrawal agreement rights, discipline it. So although the settled status scheme includes a broader class of people based on presence, if you do happen to fall within the withdrawal agreement and you find the settled status scheme provisions to be inconsistent, for example, it doesn't give you the provision for family member reunion, it doesn't apply the principle of proportionality in certain circumstances, then you can overreach it by direct application of the withdrawal agreement, but you're going to need an immigration advisor to do that.
Thank you, Adrian. The next question is, it seems likely that local authorities may be tempted to reject applications for homelessness assistance, given the usual bar on accommodation pending review under section 1883 and then pending appeal under section 2044. Is it likely that the number of breach of convention right challenges will increase, will significantly increase? Can I pose that one to Connor?
Yeah, I mean, firstly, I agree with the premise. I think we are going to see a lot more rejection on eligibility grounds, and I think we're probably going to see more by way of gatekeeping, where people are rejected at a very early stage. I mean, the particular situation that occurred as Adrian was talking is those who fall within that third cohort of persons not subject to immigration control. So those who've made in-time applications, because many people within that cohort might be people who've had their application rejected who are appealing it. The first thing local authority is going to see is the negative Home Office decision rejecting their application. So that's going to be their point of departure, and it's going to be easy for them to say, well, we don't think you're eligible. So that's the kind of case I think we're going to see more refusals. As to getting them accommodation pending review or appeal, well, we may have to try and argue breach of convention rights in those situations. The difficulty in doing so is that we're dealing with a cohort of people who, many of whom are in a position notionally to alleviate their destitution, so they're less likely to meet the Article 3 threshold. For example, if you're dealing with somebody who is in a position to work but simply hasn't got a job, it is going to be difficult to establish that they're subject to treatment for the purposes of Article 3. So it may be that the way into those cases is not necessarily latching onto the or focusing your argument solely on the breach of convention right provision, but to focus on the underlying merits of the case. I mean, I'm sure in this context you're all aware of Adrian's case of Paul Coker, which was a Mohammed interim challenge, and the point that sort of won the day on that was that the client, it was overwhelmingly clear that the local authority had made an error of law, and so the merits were overwhelming, and that essentially should have been decisive of the way that the discretion was exercised. So in the situation I've posited, where somebody who has clearly got a right under that third category, they've clearly made an in-time application and the local authority's just made the law wrong, then maybe in those cases we should be arguing that the merits of their case should be unusually, exceptionally, should be decisive of how the discretion is exercised.
Yes, and there may, I agree with all of that. I think there are cases where you are unable to work, say temporarily unable to work as a result of illness or accident, for example, that you would be, so you could be back into that regime of treatment if you're excluded, but not sufficiently unwell or have it in need to trigger any community care obligations. And there's a sort of sweet spot there where but for the provision of accommodation, it might be a breach of your convention rights, and so in destitution terms, so we could see that that area of activity reactivated in terms of that jurisdiction being used. It is possible to obviously, in cases on interim accommodation pending review to take these points, but you have to be pretty confident of your immigration analysis, because the moment it's finely balanced, then obviously there's a discretion to refuse.
The next question, I imagine quite a few people may have posed. Will Fratilla help on eligibility if the appeal succeeds? And perhaps we can have some input from both of you here, with Connor first.
Yeah, I'm happy to start this one off. I mean, this is something Adrian and I have been discussing because it seems obviously such a topical question. I mean, if the appeal succeeds in the Supreme Court, so Fratilla, for those of you who aren't aware, Court of Appeal decision establishing that the rules relating to welfare benefits, which excluded those whose only right to reside in the UK was as a result of them having pre-settled status, the exclusion of that cohort of people from mainstream welfare benefits was discriminatory and contrary to EU law. That's on appeal to the Supreme Court. If that appeal succeeds, absolutely it is going to have direct knock-on impact on homelessness law and allocation law, because you're dealing with regulations which are the mirror image effectively of that which applies in welfare benefits. I think the point that Adrian and I were discussing in more detail is there anything we can do in the meantime to make use of that? Because we have this positive Court of Appeal decision which would appear to be equally applicable in the homelessness context. Can we capitalise on that? And I think the technical answer, the legal answer is yes, there is a challenge there which is waiting to be brought to argue that exactly the same should apply in the homelessness context, that the regulations as currently framed are unlawful and those whose only right to reside is pre-settled status should be eligible. But in terms of the more practical question of getting a roof over our clients' heads, that is more difficult, because if you make an application to a local authority from somebody who only has pre-settled status, then applying the regulations as they stand, the local authority is going to find them not eligible. And so you can challenge that, you can review, you can appeal, and you can make all of these clever arguments about how Fratilla should appeal. But you're dealing with a situation where local authority would be entitled to say, well, fine, make your arguments, but we're not going to accommodate you pending review, pending appeal, because that's discretionary. So, and then when you get to courts, you may well be faced with a situation where local authority and the court are minded to adjourn your case to wait to the Supreme Court decision. So yeah, if the appeal succeeds, I think that is very significant. In the meantime, and I'm not trying to deter people from thinking about running these challenges. In the meantime, I'm not sure it's going to have that much practical impact for our clients. Adrian, I don't know if you agree or want to add anything to that.
No, I mean, it sort of drives, it basically says if the government's position is that pre-settled status is giving effect to the withdrawal agreement, then to the position under EU law, because this was prior to the end of the transition period, then you're entitled to the principles in the EU treaties which apply on non-discrimination and equal treatment. Now, so Fratilla is technically a case about EU law, not a case about withdrawal agreement rights. It's about what happens if you've got limited leave to remain during the time when full EU rights continue to subsist. Are you entitled to the equal treatment operation of EU law because you've got a regularised status? The question of whether it continues to apply to new applicants after the end of the transition period depends on whether the same principles would apply under the withdrawal agreement. Unfortunately, there are lookalikes from the treaty, the EU treaties, in the withdrawal agreement. So there's a non-discrimination clause in Article 12 and an equal treatment clause in Article 23 of the withdrawal agreement. So you can look at those and say, well, the position in Fratilla not only ought to apply prior to the end of the transition period, but it ought to apply to cases brought now, effectively. But strictly speaking, it's a different law, but it has the same substantive principles in it. So we should look forward to that. It's a positive answer, obviously, in the Court of Appeal, and the government are on a fairly sticky wicket in EU law terms with that case. But obviously, there's much to be remains to be argued over. The one thing that might be worth observing is that you could still have a reference to the Court of Justice for 8 years from the end of the transition period. So this matter of the application of the principles of equal treatment may end up in Luxembourg, no doubt to the fury of the tabloid press. But,
well, on that note, I was just going to add that apparently a reference has been made from Northern Ireland.
Yeah.
So who do we have to wait for to rule first, the Supreme Court or the Court of European Justice? Is that 2 years, or is it going to be really quick?
It's probably quicker in Luxembourg, but because they have an expedited process for this. But the funny thing is, if the Court of Justice rules on a reference from Northern Ireland on this issue, it will be binding, which again is likely to cause problems. So in a political sense, not for us, we'll be celebrating perhaps, but yeah, for other people.
For welfare benefit purposes, because of the anti-test case rule, advisors are stuck with having to put challenges in for it to all be stayed, because they won't benefit in cash terms unless they do that. So that's what we're stuck with.
Thank you very much to everyone. I think we have run over our time slightly, so I'm going to bring the webinar to an end now. But a big thank you again to both of our speakers, and to Desmond also for being on the panel.